Today, we're going to kick off our unit on the judiciary. Now, we have spent quite a bit of time at the beginning of this course examining the foundations of our government, and naturally, that led us down a road of digging pretty heavily into Articles 1, 2, and 3 of the U.S. Constitution. In our unit today, we're going to go and revisit Article 3 and really examine how Article 3, Fed 78, and the Judiciary Act of 1789 are, in fact, the origins of our American legal system. So what I want to do is kind of dig in a little bit on the history of Article 3 in the Constitutional Convention, and then I will jump right into the Judiciary Act. So at the time of the Constitutional Convention, Article 3 was, I think, the article, or the topic at least, that was perhaps considered a non-stressor, right? Issues surrounding the legislative and the executive branch were definitely more divisive amongst the framers. The small state plan, the large state plan, should there be one president? Is that more like a monarch, etc.? These are all issues we've addressed in this course already. But when it came to the judiciary, the framers just weren't as divided, and much of that is due, in fact, to the history of the judicial branch in the American colonies and in Great Britain. So both the colonies and Great Britain had, of course, a pretty well-entrenched legal system that, despite time to time the colonists might have some frustrations with about how that legal system was operating, it was, in fact, a pretty founded and well-established legal system that went back hundreds and hundreds of years. And the founders had a lot of background on the legal system and on legal institutions, as many of them were practicing lawyers and barristers. They walk out of the Constitutional Convention pretty much agreeing that they need to have a federal court system. And by a federal court system, we mean a court system that deals with laws coming out of the U.S. federal government, right? Laws made by Congress, or related to the Bill of Rights. But, there's obviously different layers of court systems in the United States. We're just going to spend our efforts talking about the federal court system in this unit. So our founders knew that they needed to have that. The founders also agreed that there needed to be a Supreme Court that was at top of the federal system, but they kind of left it at that. Everything else was not really well fleshed out, hence the need for the Judiciary Act of 1789. The Judiciary Act of 1789 is, in fact, the very first law that is passed by the first Congress. And that law establishes a complete system of lower courts that would interpret and apply federal law. So it has a holistic bottom-up court system, and I'm going to explain what that means here shortly, that examines law and applies law and decides whether something is legal or not. So it creates structure. So this act, what it does is it structures a federal system of courts by fleshing out these provisions of Article 3, by establishing the Supreme Court, circuit courts, which are sometimes called appellate courts, and district courts. And then it also establishes jurisdiction, which I'll talk about here shortly. So what does this federal court system look like? Well, of course, at the top, there's going to be a Supreme Court. At the top of the Supreme Court is a Chief Justice. That is the person who organizes the work of the court. Don't think of the Chief Justice as like the president. It's not the same. But what the Chief Justice does is manage the court. And we'll look a little bit more at that in this unit. And in 1789, the Judiciary Act established that there'd be one chief and that there'd be 5 associate justices. So today, for example, we have Chief Justice John Roberts, Associate Justice Alito, Associate Justice Ginsburg, Associate Justice Sotomayor. We typically just call them Justice Sotomayor or Justice Alito. So at that time, there were six. In 1869, it was established by law that there would be 9 members of the U.S. Supreme Court, and there have been 9 ever since. There was, for a brief blip in history, a movement to increase the size of the court in the 1930s by President Franklin Roosevelt. He called it the Court Reorganization Plan. But the intent behind the court reorganization plan was ultimately to stack the court in his political favor to pass New Deal legislation related to the Great Depression. The Judiciary Act of 1789 also creates 13 district courts. And what are these 13 district courts? Well, basically, every state that had ratified the U.S. Constitution would receive a court. And Maine and Kentucky would also receive courts, although they were not states at that time. Each district court was presided by 1 judge and staffed by 2 Supreme Court justices. So each district court would be made up of 3 judges total, and then each district was broken into regions. North, south, east, west, and the judge would literally ride the circuit. In fact, cases would not come to them, they would go to the cases. In terms of specific jurisdiction, one of the things that the court does is it defines the rules as to which court gets what types of cases. So, for example, it defines the parameters of the authority for each of these kind of cases and for the Supreme Court. So, for example, district courts serve as minor trial courts, right? We've talked about this a little bit when we were studying our civil liberties and civil rights. So oftentimes when people had a case that they would bring to federal court saying, hey, this law is a bad law, Ohio's provision on blah, blah, blah is unacceptable. It's a violation of the Fifth Amendment. You introduce that case in district court, and then you have a trial to determine whether somebody is guilty or not. That happens in the district court level. At district court, the justice or the judge, we would say in this case, hears cases and they determine penalties on federal crimes and minor U.S. civil crimes. The circuit courts are also trial courts, and they have jurisdiction over more important civil issues and criminal matters, and have appellate jurisdiction. Appellate jurisdiction means that a case comes from the district court up to them, and they're being asked to decide whether the district court was made a good decision or not. And then lastly, the Supreme Court. Now, the Supreme Court is called the court of last resort. It is an appellate court in most situations, meaning that it hears appeals coming out of the circuit court, and it also hears appeals coming out of state courts. I told you there are different layers of courts. And there are state courts, and state courts exist to deal with crimes that have happened within the state. So let's say in the state of Washington, a crime occurs. It's a state law. It's not a federal law. You want to challenge the decision that was made by the Washington State Supreme Court. You can, in fact, challenge that with the United States Supreme Court. Hopefully this slide will give you a little bit of an example of these different layers. So the district court is where most cases in the federal judiciary system originate. There's today at minimum 50 of them. In fact, there's now 94, 50 because each state is given a district court. Some states have more than one district court. Washington has 2, and my next lecture discussion is going to cover more of the structure to make more sense to you. If you don't like your decision at the district court, you can appeal to the Court of Appeal, or what's called the circuit court or appellate court. And if you don't like your decision at the Court of Appeal, you can choose to appeal to the U.S. Supreme Court, the highest court in the land. So hopefully that gives you a little bit of just a taste of what comes out of the Judiciary Act of 1789. I'll just finally add, we examined in Unit 1, Marbury v. Madison. And Marbury v. Madison is very much a test of the Judiciary Act of 1789, arguing sort of what is the role of the Supreme Court and what is the role of Article 3. But I'm not going to spend my time digging in on the issue because that's something we've talked about already. So when you see me again or hear me again, we're going to look a little bit more at the organization of how the courts operate and what their jobs specifically are. And then I'm going to set you loose on watching, or rather listening, to Supreme Court arguments because they are being broadcast live over the next month due to the pandemic. So you have a real opportunity to hear Supreme Court arguments in ways that you wouldn't have had an opportunity to listen to in other circumstances. So anyway, I hope this screencast finds you well, and I look forward to answering any questions that you might have.